to mention, Lordship, in the item rating 73 of the hearing list, actually that will be that was from 3/1/24 to 2/2/24. So these items, there is another item also 72 tagged. So these items have already been in the list, but only issue was already decided relating to acquisition of national land. So these items may kindly be taken up on 1st of February. I have also been instructed by my senior counsel BC that
We'll try to see. We'll try to
2015.
explore.
14 and 15 matter.
We'll explore that possibility. Let
Thereafter,
be on. First, we'll examine.
thereafter. Oh,
We'll examine,
definitely.
depending upon the business of the court.
May I please your lordship? Prepare for listing the matter on Thursday. This is the eviction matter. There is an urgent selling eviction notice.
Selling
Eviction notice.
eviction notice. Motion.
Motion.
Motion. When?
Thursday.
Huh?
Thursday, my lord.
Let it be on Friday. Friday? Second?
May I please your lordship? I apologize for troubling lordship. In item number 13, lordship, we have filed an IA lordship yesterday.
13.
Yes, 13 lordship. Lordship, may I call it for
IA.
yes, lordship. And the IA is particular for we are praying for a stay, your lordship, because the buffalo fight, which is beyond the time limit, is going to be held on 4th of February, your lordship. So we are praying for a stay in that IA lordship. Sometime.
4th of February.
Yes, lordship. Lordship may be taken up today, your lordship.
That listing of IA will be difficult then.
Lordship, actually, the read petition is already listed, your lordship. And the IA is still yet to be numbered, but it is filed yesterday, your lordship. It will come.
Yet to be numbered. That is
Lordship, it will
difficult.
come. It will come, lordship. I'll make sure. I'll assure lordship. I'll make assure lordship.
Let us reach item 2.
Yes,
13.
okay.
Lordship,
Lordship,
I have a motion for listing, Lordship. Matter relates to Lordship, now confident motion, Lordship. It was listed yesterday, Lordship, but not very, Lordship.
File of next week. Next week. Next week. We'll see.
Which I'm paying for listing of matter for motion on Friday matter. It's regarding GST matter.
May I please your lordship? I'm paying for listing on the matter lordship regarding eviction lordship. Friday lordship.
Friday.
Lordship, I beg to mention item number 10, Lordship, matter may be fixed on next week.
Lordship, I'm appearing for the petitioner in this matter. Lordship, on the last occasion, Lordship, the stay was subject to the deposit of the principal. I mean, Lordship, we have paid that. That may be recorded in Lordship.
What prayer
Lordship,
you have?
my senior is out of station, Lordship.
Okay, let it reach. You be there. Recording of some other facts are required. So you be there.
May I please your lordship? Lordship, I beg to mention a writ petition for listing. Lordship, matter pertains to establishment of brick industry. Lordship. Another matter.
Pursue the matter before the registry.
Lordship.
Pursue the matter before the registry.
Please, Lordship, I beg to mention an writ petition for urgent listing. Lordship,
Subject matter.
Lordship, this is pertaining to a stay that is operating against the Director General in a case of cartelization.
Motion.
It's for hearing, your Lordship.
It's for hearing. Pursue the matter before the registry.
Lordship, I've already filed an
Make an
application.
application.
I've already done that, Lordship.
Okay. Bring it. The application.
Yes, your Lordship. Sure. Much obliged.
Show it to me.
Promotion item number 12.
May I please your lordship? My lord, the root question is the land where I have built a RCC house, my lord. ground floor. It within the jurisdiction of the Gaon Panchayat, who has given me the no objection to build it, my lord. And now, repeatedly from 2018, the District Development Authority is serving notice, but when I give them the reply, they don't say anything. And now, the last one they have given in the month of January, my lord, this month. If your lordship only comes to
Page 63.
page 63 only. My lord, I don't know at whose behest this chairman is repeatedly doing. If your lordship looks at the earlier one, my
Now-
lord, this is
Development Authority is constituted under what statute?
my lord, under the Town and Country Planning
Let
Act.
us see.
Yes,
Do they have any authority or not?
they have some kind of a master plan authority in respect of the urban areas and semi-urban areas. That is, if we see the authority in the, my lord, in the definition,
This is only in a notice to submit building permit.
yes, my lord.
So
My lord, from 2018, when they have said, my lord, I took the land from the agreement holder who agreed.
no, whether this gives rise to a cause of action to file a writ petition.
Yes, my lord.
Show
Because,
me Assam County Planning Act.
my lord, if your lordship looks at the,
এখন দিও আসাম টাউন এন্ড কান্ট্রি প্ল্যানিং
my lord, the notices from 2018 are beyond jurisdiction, my lord. Beyond jurisdiction of the development authority, my lord. Within panchayat area, it is the local panchayat who gives the permission. And if your lordship looks at the
Right.
definition,
23.
my lord, if your lordship looks at the definition at section 2, over there only, my lord, it will come to the picture that they are only in respect of implementation of the master plans and other things, my lord, in respect of urban and semi-urban areas, my lord. That is, minimum for them is the municipal authority, municipal areas, not the Gaon Panchayat.
To raise the issue of jurisdiction or territorial jurisdiction, one has to have the notification regarding whereby the territorial jurisdiction of the development authority has been made clear. Whether your area comes within the area of development authority, that is a question of fact. Do you have the notification? Wherefrom you can clearly show that this area does not fall within the jurisdiction of territorial jurisdiction of the development authority.
My lord,
Otherwise, if I remember, maybe 13. Maybe 30. Section 13. If the plan is published under section 10, no person shall use any land, subdivide any land, or set up any structure by transfer, by way of gift, sale, partition, or any other manner, the whole or any part of the land, or any land covered by the plan, change the existing structure of any building, or use any building or land within the area, except with the permission of the authority, on the written application submitted for that purpose. Now, question is, if the area comes within the development authority, then under section 13(2)(a). And 13, more particularly 13(3), the authority may also call for such other information as it may deem necessary to examine an application. So that power is there, but question is whether your area falls within the development authority or not. That is the issue you have to show and dislodge.
My lord, I would like to.
Otherwise,
My lord,
this is just calling for information. And allegation, it is still at the stage of allegation. You have to respond to it.
my lord,
And you are saying is that they have been issuing such kind of notice to you.
only me. Where my lord
Okay,
is,
that does not mean that
no, where my lord has said that the plan, that is in respect of the, if there is any master plan in respect of the land across that area,
because a development authority comes into existence when there is,
a master plan.
yes.
But over here, there is no master plan.
We do not know
Only-
why the state government will constitute, see
Well-
the definition of development authority.
My lord, that is section 2A, I suppose, my lord. 2(1) in the definition. But I have due permission from the panchayat, my lord. When I built it in the 2016.
They want to examine as it appears.
No, I've given them the reply every time. They're asking for the land document. I don't have the land document because there is a dispute between X and Y.
Oh,
There is a between X and Y, and there is a case, and ultimately there is a stay order by this honorable court in respect of the Y who agreed. And that land is part and parcel of that land where I have built the house because I have bought it from the Y, my lord.
There is for an unregistered agreement.
Yes, yes, because the sale did not culminate into the finalization between X and Y, and I bought it from the Y. There is a civil suit, and ultimately when the stay was not, injunction was not granted, they approached this honorable court, and this honorable court gave the restriction, my lord. And the land which is in question, my land, my house is part and parcel of that land. And that order is, my lord, in page 52. But house, the house where I'm staying is from 2016. That is the only shelter I have.
and Mr. Abedin,
Yes, my lord.
as per the Assam Town and Country Planning Act, just because notice indicates that, where is that page? 63.
Yes, my lord.
That please submit your building permission, if any, along with all the land documents before this office within 7 days from the date of receipt of this letter. Stop.
Yes.
Next, failing which, necessary action will be taken as per the Assam Town and Country Planning Act.
Yes, my lord.
Right. Now, do you have the act also? Because
My lord,
we
no,
are
my-
having your book.
My lord. My lord, would you allow-
Subsection 4A,
Yes, my lord.
section 13. Right. If any person carries on any development work or retains or the use of any building or work or continue to use the land in contravention of the provision so and so, or of any permission granted under so and so, the authority may direct such person by notice in writing to stop further progress of such work or to discontinue any use, and may, after making an inquiry in a prescribed manner, remove or pull down any building or work carried out and restore the land to its original condition as the case may be. So that proceeding has not been drawn up. That is why it is indicated that failing which,
My lord, would your lordship be-
action will be taken as per the Town and Country Planning Act.
Would your lordship be-
This is just asking for document. That will not give rise to any cause of action to institute a writ petition.
My lord,
This
would you-
appears to be premature.
My lord, would your lordship be pleased to see-
When a notice, show cause notice is issued under section subsection 4A of section 13, then only you have to respond to that. And if any effective order is passed, thereafter, cause of action will arise.
My lord,
This is not a show cause notice even under subsection 4A of section
Yes, ma'am.
13.
Would your lordship be pleased to see page 56 once, my lord?
Not required to see any more thing.
My lord, just for satisfaction, my lord.
Same,
Yes. No, no, what I'm saying,
same.
this is 2018. Then I reply. They don't say anything. Don't say anything in respect of my reply. My lord,
You have responded, that's all.
no, then 59. The second one. There also I reply. They don't say anything. Again now, recently this one. I don't know at whose behest they are sending this, my lord.
We are not going behind the curtain. We'll only look at the content of the notice.
My lord, I am only scared of that curtain, my lord. Who is behind?
No, we are not lifting the curtain. We are not required to lift the curtain. It appears that you are not the owner of the land,
I'm not.
right?
I'm not.
And you have constructed the building.
Yes, my lord.
And then
My lord, what I'm saying, this happens. my
your
lord.
very credential is doubtful.
No, my lord.
Be that as it may, but this will not give rise to any cause of action to maintain a writ petition. Had it been an action under subsection 4A, then it would be of section 13, it would have been at least some kind of cause of action. Though a show cause notice does not give rise to any cause of action. It is not even a show cause notice. It is a prelude to a show cause notice,
I understood, my lord.
which may not ultimately result to a show cause notice.
I understood, my lord.
So, meaning thereby, it appears to be a clear case of premature institution of writ petition. We can observe that a cause of a petitioner may have a cause of action, might have a cause of action in the event any notice under subsection 4A of section 13 is issued.
Anything,
We can observe that.
anything. My lord,
We would not like to
if your lordship,
keep this writ petition pending just for the sake of keeping it
my lord, if your lordship,
in the docket.
my lord, if your lordship closes the writ petition with that observation, my lord, then it's okay, my lord.
Yes,
Actually, notice was issued by the Boripur Development Authority. I'm not representing them. Otherwise,
But-
yes,
they have, if it comes within that, in your reply, you can say that this area does not come within the territorial jurisdiction of the development authority. If such a issue is raised, the authority will consider that issue.
I understood, my lord.
Right. And
As far
secondly,
as I
on a
understood.
privacy look at the notices, it does not appear
But
that
what-
it falls in the category of a so-called notice as contemplated under section 4, subsection 4A of section 13.
My lord, if I have shown, my lord, all the notices, they don't even say under which section they have issued the notice. That only,
Source of power, if otherwise available in the statute. Whether they have the power or they have the power or not, they have the power to issue a show cause notice. To asking you to show cause as to why this building or structure is not to be declared as unauthorized construction. They have the power under subsection 4A. We are not going behind the curtain, Mr. Bin. Heard. Mr. P. Abidin. Learned counsel for the petitioner. And Mr. N. Kusami. Learned junior government advocate Assam for respondent number 1 to 4.
my land is appearing for one.
I'm looking for one minute.
MSF
Okay.
Shutia. Then 2 also.
Minute. One.
Learned Council representing Mr. P. Nair. Learned Standing Council, Housing and Urban Affairs Department. And Mr. N. Goswami. For 3 and 4. Learned Junior Government Advocate Assam. That's for number 3 and 4. Full stop. In view of the issue raised in this writ petition instituted under Article 226 of the Constitution of India. This court is of the considered view that the writ petition can be disposed of at a motion state itself without issuing any notice to the other respondents, party respondents included in this writ petition. Full stop. The petition has approached this court petitioner has stated that he is compelled to approach this court due to issuance of three notices. Three.
Yes, Madam.
Okay. Three notices. That's dated 14 to 2018,
Yes, Madam.
comma, dated 18/8/2023
Yes, Madam. And
and dated
6/1.
6/1/2024. Yes. By the Dhubri Goripur Development Authority, comma, Dhubri, over a period of 6 years. Similar notice, similar good. Comma, without bringing the process into any logical conclusion, comma, despite submission of responses by the petitioner to the notices dated 14/2/2018 and the notice and dated 18/8/2023. Right? You have responded to the previous two notices.
Yes, Madam. Even this one also,
Okay.
in all the three
Despite-
notices.
Okay. Despite submission of responses by the petitioner to all the three notices. As the process, as despite submission of response, not replies, quick. Replies to the notices, the process initiated by the so-and-so development authority has not been brought to any conclusion, comma, the petitioner is before this court. Full stop. Mr. Abedin, Learned Counsel for the petitioner, has submitted that the building constructed by the petitioner on the plot of land in question comma, is in occupation since the year 2000.
2011.
Sorry, the plot of land in which the concerned building is constructed, is under occupation of the petitioner since the year
My lord,
2011.
2011. And my lord,
And
built of
full stop. The petitioner has further contended that the
Annexure-
building has been constructed
Annexure
after due
5.
permission
Annexure 5 to.
from the Gaon Panchayat authorities.
Yes, ma'am.
Full stop. It is a further case of the petitioner that the plot of land does not come within the territorial jurisdiction of the
State Development Authority.
Hubli Gauripur Development Authority. Full stop. And in such view of the matter, the notices issued to the petitioner are without jurisdiction. Full stop. Para Mr. Goswami, Ms. M.S. Chutia, learned, and M.S. Mr. Goswami, learned counsel appearing for the aforementioned respondents, have submitted that by the said notices, the petitioner had stroke, has been asked to submit few documents like building permission, approved plan, along with land documents, of the petitioners related to the petitioners residential stroke commercial building at Jhagra, part 1, 2. Full stop. It has been contended that the notices do not go to show that the same are any show cause notices. The same are notices under the provision of subsection 4A of section 13 of the Assam Town and Country Planning Act, 1959. Full stop. According to the Land Council for the respondents, the notices are only for the purpose of effect finding and inquiry, as the notices have clearly indicated that necessary action under the provisions of the Assam Town and Country Planning Act 1959 would be taken only in the event of failure on the part of the petitioner to submit necessary documents, as have been asked for by the notices. And full stop. Para. On perusal of the contents of the notices, which are more or less similarly worded, it is noticed that the petitioner has been asked to submit no objection certificate for building permission comma, approved plan along with land documents in relation to the residential stroke commercial building at Jagra Part 1, Dhubri by the Dhubri Goripur Development Authority. Full stop. It is also noticed that the petitioner has averred that he has responded to all the three notices. By submitting replies in writing and explaining full stop. As per the provisions of the Assam Town and Country Planning Act, a development authority constituted under Section A of the Act exercises jurisdiction over such area as specified by the state government in the concerned notification published in the official gazette. Full stop. The petitioner has raised an issue that in his written replies.
That issue was not answered, that this area is not within the development.
Have you raised an issue?
No, in the explanation, that is not there.
Okay. Full stop. The subsection 4 A of section 13 reads as under 40. It's 25 minutes. Though the petitioner has also raised an apprehension that the building constructed by him might be demolished by the Goripur Development, this Dhubri Goripur Development Authority in course of time. Full stop. As per the provision contained in subsection 40 of section 13 of the act goes to indicate that if the development authority if any development authority contemplates any action to remove or pull down any construction, the same has to be preceded by a show cause notice and an inquiry in the prescribed manner. What is the prescribed manner? Any rules? Any rules, Mr. Abedin?
No, man, I couldn't get it.
Hmm? Prescribed means what? As per the definition?
It's already there.
Hmm?
It's already there.
I mean, prescribed means prescribed by rules made under the Act. Rules might have laid down how this inquiry is to be conducted. No idea. Nothing. Some town and county planning regulation targets, planning and management. Okay. Full stop. Insofar as a matter of, insofar as a show cause notice is concerned, comma, it is right that a show cause notice by a show cause notice, try to observe that by a show cause notice, comma, a notice is asked to respond to the proposed action. with the issuance of a so-called notice, the rights and obligations of the parties. Have not been decided finally. Full stop. The event of so-called notice is a step towards taking a final decision in the matter by the competent authority. Full stop. A tentative view taken in the process cannot be deemed to be the final view in the matter, as the final view in the matter will be dependent upon the response received from the noticee. And if the noticee is able to show sufficient cause as to why no action as contemplated by the show cause notice should be taken, the final view may altogether be different. Full stop. It is settled position of law that ordinarily a writ petition is not entertained against a mere show cause notice, as at that stage the writ petition is premature. Full stop. A mere show cause notice does not give rise to any cause of action, because it does not amount to an adverse order which affects the rights and rights of any party. Full stop. It is also settled that a show cause notice does not ordinarily infringe the rights of anyone. Full stop. It is only when a final order is passed affecting a party, then the said party can be said to have any grievance. Full stop. Read jurisdiction, which is extraordinary and discretionary. Read jurisdiction under Article 226 of the Constitution of India, which is extraordinary and discretionary, is not ordinarily exercised to quash a show cause notice, save and except in some exceptional cases, like want of jurisdiction on the part of the authority issuing the show cause notice. Full stop. The notices issued by the notices, indicated above, by the Gauripur Development Authority. Even a look at the notices issued by the development indicated above, issued by the Koripur Dhubri Development Authority. Do not go to show that those are show cause notices. And no, do not go to show that they fall in the category of show cause notice. Full stop. From the contents of the notices, it transpires that they have been issued in the process of fact-finding inquiry. Full stop. As the petitioner has already responded to all the three notices by submitting his replies in writing. The petitioner stated that here has number. Full stop. One of the what also appears to the court that the Dhubri Goripur Development Authority has been issuing similar kind of notices over a period of 6 years to the petitioner without intimating the outcome of the process initiated by the notice issued as far back as on 14 to 2018. Full stop. In such view of the matter, this court observes that the process initiated by the three notices indicated above should be brought to a logical conclusion by the Dhubri Goripur Development Authority as expeditiously as possible, by informing the outcome of the same to the petition, forthwith thereafter. Mr. Goswami, can you represent this authority?
No, Lord.
Huh? This court further observes that if the Goripur Dhubri Development Authority contemplates any action under as per the contemplates any action under subsection 4A of section 13 of the Act, then such action shall be strictly in adherence to the provisions contained in. No, if it contemplates any action like removal of the building, as apprehended by the petition, then such action must be in strict adherence to the provisions contained in the Act of 1959, more particularly, section 13 thereof. Full stop. I will go. Not even show cause notice. No. Thus, the repetition. Am I in the considered view of the petitioner? Is a premature one. The same is not entertained. So stop. However, other actions.
But instead of,
Premature.
and instead
I
of,
would have dismissed it.
can I say one word on that? Instead of, not entertained,
Not entered. Not entertained. When it is not so cause notice. I have observed only. It is not even a so cause notice.
I understood,
I have observed.
I understood, my lord.
Even a so cause notice, challenging a so cause notice is not to be, though maintainable, not to be entertained, except in,
I understand, my lord. I got something because there are 3 similar notices. If there was one, I would have been out already.
except in few situations, as Mr. Das has argued, lack of jurisdiction.
Deeply obliged, my lord.
Morning, my lord.
Yes.
Just recollect, I just mentioned on that day.
Yes, yes.
That is not to be so urgent in this case, because the period which they have mentioned is 15 to 25.
25, yes, that,
Now period, but so far as Bulbul fight, no particular dates had been mentioned. So I thought I should bring notice to the court. A declarative relief has been sought for in this case, my lord. Your lordship has to examine this matter, because there are few judgments of the Supreme Court. My lord, there are 2 acts. The prevention, I'll just tell your lordship before going to the Prevention of Cruelty Act 1960 and Wildlife Protection Act. These 2 acts is a central act which has been made. So central act has to be consistent with any law which is made by the state. Now, we don't have, our state doesn't have any act. So they have to follow the central act. That's, my lord, your lordship is aware of it. Judgment of E. Nagaraj, my lord, if your lordship looks into judgment of E. Nagaraj, they said, my lord, they brought it so many ways. They were holding some events, sports like event. So they came up and they in Nagaraj said that you cannot held those events because it is against the provision of this act. So they made it very clear. Now, after Nagaraj judgment, because some states were having those events, Karnataka having events, Maharashtra was having events, Tamil Nadu was having events. Now, all those events, they said, how can you hold this event? It is unless there has to be some amendment, you have to take assent of the president. So that judgment stands. Our state doesn't have any amendment. Now we challenge it because the SOP has been brought before this on by the government, state government, saying these are customary. So 15 to 25 more Jews, so it should be held. So we missed the bus because of period of timeline period. But even then we have come to the court, we are saying, please, my lord, examine this matter, look into this issue, because there is, unlike those 3 states, we said the assent of the president, you don't have an assent here. How can that be over it? That's number 1, my lord. How can you over it? You cannot over it. You have to bring the amendment. You have not brought this amendment. Secondly, my lord, we have to, what is the provision under the act? Your lordship will kindly look into it. They have violated all the provisions, my lord. They said by the SOP, they said we'll take all the case. But if your lordship looks into it, we have given some photograph. All these 3 states, it is not between animal to animal. It's a race. It's a race, my lord. So it is not like animal to animal, which is against the provision of the act. I'll show it, my lord, during the course of hearing, my lord. What today I am apprehending, that today my learned friend has mentioned before the court for an IA which was moved. And we want to bring notice to the court, even in spite of the notification issued by the state government, say these are customary modules, so 15 to 20 feet. Beyond that, no event
so
will take
far
place.
Mojuji is concerned,
Yes.
Whether that issue has been reignited again, or after 25th, there is no,
That's the whole problem.
no.
My lord, so far as state government, my lord, we have brought notice to the court by an IA.
Oh, this is the SOP, page
Yes,
42.
yes. Kindly see SOP, my lord. Before that, if your lordship kindly look into page 41.
What about Bulbuli? So far, Buffalo
Yes,
is concerned, it will be allowed only from 15 to 25.
but even then, I brought an IA. Some events are taking place. Not even the government. Government has got the SOP and they said these are the period. But I am kindly see an IA, my lord, just it is not before your lordship is not allowed.
If somebody without government permission is
can they
doing,
hold-
no, that will be a case of offense.
This is an offense, absolutely.
That
my
will
lord.
be a case of offense.
Correct, my
But
lord. Their penalty is-
government permitting an event
Yes.
without jurisdiction or
Yes.
without bringing a law is one thing.
Yes, right.
And
right.
somebody,
The not taking permission for the government
some
also.
unscrupulous person holding a buffalo fight
Yes.
without any government permission is one thing.
That's
That is
what-
an offense.
That's what my
That is
lord,
criminal offense.
that's what my prayer is that government should ensure, my lord, no such events takes place. The Lord, this event will go on. That's why I brought an IA, my lord. SOP,
No, when is going to be held?
this is like
What the,
4th February, my lord. Last page, my lord, 4th February. Government should ensure, my lord, no such event takes place, my lord.
so far this IA is not listed, but still.
They
It
should-
can be listed day after tomorrow, but this is 4th February. At least it indicates
On the second,
something.
on the second aspect, Lord, I'll take instruction on Friday, Lordship may take on second, Lord.
This one, so far, this one is concerned, you can take instruction.
Yes, sir.
Because as per the government SOP,
It should be
it should be held between 15 to 25.
25th.
And that's what your lordship is right. But we will argue before this court that this also was illegal. How they can do it, my lord, your lordship know that law is very clear, my lord.
Ah,
Well, that's another part where
One
lordship
part.
has said.
One part that SOP authority on the part of the state government to issue such an SOP
Correct,
is the question raised,
correct, right,
right?
right.
Now, here some individual
Yes, come on.
has come up with buffalo fight. That will be an offense.
My what?
That
Yes,
will be an offense.
you're absolutely correct.
Ah,
And they
because
cannot.
it requires permission from the government and follow the prescribed procedure.
And there is no question of taking permission of the government.
This is a criminal offense.
My lord, yes, I'll give a quick reply to your lordship's query. So there is no question of taking any permission from the government. Government indicated in the SOP, so far as bullfight is concerned, we have given a period, 17, beyond that. Kindly see, my lord, kindly see that.
Have you lodged any FIR there?
No, we are going to take up
You
this
lodge
action.
better you lodge the FIR here. So far, this one is
No, your lordship is right.
because see, testing the validity of the SOP is one thing.
Yes.
Only the,
Some individual
that's what my instruction is that.
in violation of say Wildlife Protection Act or other animal
The
prevention to
of
cruelty
Cruelty Act.
to
yes.
Animals Act, that is individual offenses.
Yes, yes.
But government
But the.
issuing the SOP,
But-
that is
My lord-
tested on the constitutional
No, my lord,
parameters,
correct.
right?
Your lordship is right.
And
Also,
statutory
my
parameters,
lord,
but
your-
this,
I'll give an answer to this, my lord. Your lordship said, why don't you lodge an FIR? My instruction is they have gone, but they are not registering any case. That's the whole problem. I may come up with an IA stating what they have done it, why they have not done it, and when we have went, we'll come. But the only prayer, limited prayer today is that they cannot hold any event without taking permission from the government. Because now, kindly see, my lord, what indicated, these are mentioned about the date, 15 to 25th. How you are allowing? Government should ensure before the court, they will take the steps. Government should ensure, my lord. I am troubling your lordship, but government should ensure and say that no, we will not take any step. We'll see from our side. They should issue a notice, public notice. Please don't hold any such event.
Lordship may kindly take up 43, page 43, the SOP number 1, my lord.
SOP so far, I have just, I'm
Number-
just having a cursory look.
Number
Page
1,
43, so far
Page 43.
buffalo fight is concerned,
1.
clause 13 says, a written undertaking for complying with the rules incorporated in the SOP should be made compulsory from the organizing committee for obtaining permission from the district administrator.
Lordship may kindly also, 1.
If it is brought to light by the IA, suppose,
Sure.
which is to be listed. If there is no written undertaking, first point,
First point,
without going into the validity,
yes, yes.
Right,
the emergency
right,
situation,
right.
then there cannot be any
But
modules. Otherwise,
For-
SOP says 15 to 25.
15 to, and that apart, serial number 1, kindly say concerned district commissioner will issue permission to the organizing committee on the basis of the application from the organizers.
Which one? Which
Number
one?
1. Number 1.
Huh.
The district administration should ensure that all rules and regulations along with the SOP is strictly followed. Concerned district commissioner will issue permission to the organizing committee on the basis of the application from the organizers. So on this, kindly give me 2 days time on
Please,
Friday, Lordship. will take.
I'll
Just
I'll
have
take
all-
this
No,
time.
your lordship,
Clear.
You take
Your-
this,
My lord,
copy of
my-
this IA,
my
go
lord-
through it
Yes,
and
yes.
take the
I
Lord
have-
will kindly look.
instruction.
No, my learned friend read 1, kindly read 3.
No,
Kindly,
I-
for a moment, no,
That I have
kindly,
seen,
I'll
that I
give a
have seen,
reply.
that I have
Kindly see 3, my lord, at page 43.
I have read.
No modules shall
I've
be
seen.
allowed any time of the day except the period stated.
Yes,
So
sir.
then how can you make it saying that no, so
No,
this
we-
is become a customary tradition, so it should be allowed.
Sir, let me have the instruction.
Which
I have not
place?
said so.
Kattigor, Singimari district?
I have not said.
For-
So,
I'm-
District?
District which should be, Jorhat.
Sure.
in the IA, I have seen,
I am not
they have not
the-
said that they have, they went to file FIR, lodge FIR, it was not accepted, that those are not there. In any case, my lord, I'll get the instruction by Friday.
My lord.
Because
If at
individual,
all the district administration has
Suppose-
given them permission.
yes, Mr. Nath conducting a module without
I'll-
permission,
Permission is
then
required.
that will be a violation of the statutory statutes. That will be criminal offense.
Correct.
Violating the SOP is one part and violating the statutes is another,
Lordship.
right?
My lord, yes,
Individual
yes,
conducting a buffalo fight,
yes.
not only in violation of the SOP,
Yes,
but it might be violation if of the
Prevention
That
of Cruelty Act.
cruelty
1960.
to Animals Act
Yes, Animals Act.
or maybe wildlife, whatever.
Yeah, Wildlife Protection Act.
But we are testing in the repetition,
Yes.
the issue which has been raised is that the validity of the SOP.
Correct, absolutely right.
That's-
That your lordship can decide anytime, man, validity of SOP.
In that,
So far,
because
this
my
kind
lord-
of incident is concerned, that can be taken care of in the eyes.
One
Yes, sir.
thing is very clear, my lord, your lordship dealt so many matters. How can they bring a notification without the amendment? State has not brought any amendment of the central law of 1960. All these 3 states, my lord, if a lordship sees a judgment of 3 states, later on I will deal this judgment. I will submit before your lordship.
What is this page 41?
Yes. 41 is a notification, Gazette of, this is by the Government of India. Kindly see, Ministry of Environment and Forest notification, 11 July.
Prevention of cruelty
Yes, and in supersede notify government artswhile,
to animals.
except a restricts, respect things done or omitted to be done before such suppression. Central government hereby specifies the following animal shall not be exhibited or trained as performing animal with effect from date of publication notification, namely 1, 2, 3, 4, 5, 6, 96 bulls.
Now,
Specific notification has been issued. And you know
no,
why?
no, just 1 minute for
Yes.
my understanding.
Yes.
Whether bull and buffalo are same,
I will suggest.
I don't think so.
Yes, yes.
No.
No, wild buffaloes are called wild buffaloes, male. I will show it, my lord. I'll
No,
show it.
show me
before-
that they may be of the same genus.
Yes,
Genus.
yes.
But might be different species.
No, it's male, my lord. Then I will
No.
show it. No, I'll show it.
Bull. Let us see.
Yes,
Put it
Bull.
bull and buffalo.
yes.
Put bull and buffalo.
See, bull and buffalo.
I'm more pet to not. Just to examine.
Yes, yes, of course. It should be, everything should be. clear.
Buffalo, we say moh.
Hmm.
Bull, we say
Hmm.
harguru.
Hmm.
But so far prohibition is concerned, it is bull.
But this is what the judgment of the Supreme Court, Karnataka event, that's buffalo. That's buffalo, how the Supreme Court has dealt. Because it's a bull, ban of bull. So it's a dealt.
This notification deals with
That's
bull.
also, no, that's also buffalo in Karnataka, my lord.
Yes, bull and buffalo.
Yes. Male buffalo called bulls.
Yes.
This is what I found, bulls, male. Male buffalo called bulls are 6 feet tall and their hump and weigh over 2,000 pounds. They protect the herd and growl. Bulls, males, my lord. Kindly see, my lord. Bulls bracket males.
Hey, rejection, bull and buffalo
Hmm?
difference.
Yes, sir. It provides, my lord.
Bulls are uncastrated adult
Adult
male.
male.
Adult males of the
Both
species.
florals, while buffaloes are large cattle-like animal belonging to the
Hmm.
subtribe buffalo. While
While
bulls
bulls are male
animals,
animals,
they
there are
they are
both male and
female
female
buffaloes.
buffaloes.
Thus, this is the main difference between bulls and buffalo.
Ah,
Yes.
there will be a picture,
Yes.
pink and blue.
Yes.
I think we are looking
Yes.
at the
Yes.
same,
Right. Same.
same, pink
Yes.
and blue.
Yes.
There is a picture.
Yes.
Bulls are uncastrated,
Hmm.
uncastrated adult male of the species Bos taurus.
Yes.
Buffaloes are large cattle-like animals. Cattle-like animals.
Yes.
Bull is cattle.
Yes.
Belonging to the subtribe Bubalina.
Hmm.
Bull, male animals. Buffalo, there are both male and female buffaloes. Bull, used for dairy farming, beef ranching, bull riding, and bullfighting. Buffalo, water buffaloes are used for agriculture and African buffaloes are used for meat. Bull,
In a
some
bull,
species
my
do
lord-
not have horns.
No, bulls, if you say bulls, it is only male.
Male, cattle.
Male, cattle. But if it is buffalo, can be male and female. Buffalo.
So
Both.
basically, bull and buffalo may be two species
Yes.
out of the same genus, but bull and buffalo are not equal.
But
Same,
even,
identical.
no, even then.
Not
No,
identical.
no, like, let's forget. and
Prima facie view, I am
let's-
not expert.
No, Milo, let's forget about the notification.
Okay.
Even then, they cannot hold it. Because it is violation of the Prevention of Cruelty
We'll
Act.
go into that.
This will go into that.
No, we'll go into that one by one. So far, this
Can
notification is concerned, it
Yes.
is not specific to buffalo.
But can I say one thing? Page 43 kindly be looked into it.
So for 41, we are, I'm
43.
just,
No, 41 is bull. 41 is bull. Kindly see 43. 10. 43, 10.
buffalo.
Yes. Only male buffalo shall be engaged.
Yes.
So that means, my lord, yes, that's my lord.
Only male, bull means male.
Ah.
Buffalo means both male and
Male
female.
and female.
But
And this notification says only male buffalo.
let's say that, okay, let's go give,
Look,
we
We
forget.
are understanding.
We'll try.
Mr. Das, I am not disputing anything.
No, your lordship is
We
right.
are
We,
trying to understand.
no, your lordship, definitely, your lordship will ask question, then only I can give a reply. Then it will be, clarity will be there, my lord. If there is no interaction, then where, my lord, I'll just argue there will be no interaction. But even, my lord, as on date, my lord, they cannot issue this SOP itself.
Let us go, let us flip the pages one by one.
Yes.
Say, page 47
42,
onwards.
42.
47 onwards. Just let us flip the pages.
Yes,
Both Mr. Das and Mr. Nath.
yes. 47 is, my lord, judgment.
This heading says, case note,
Yes.
bullock cart race.
I'm sorry, yes,
Miscellaneous, cruelty to animal,
Yes.
bullock cart race.
yes.
Right? Just
True.
having
Cursory,
cursory. Then
Cursory
page
look.
51.
Yeah.
Bull's behavioral ethology.
Yes.
Then Zalikatu.
yes.
Zalikatu means Tamil word which comes from so and so. Tied with bulls.
Yes,
Page 52.
yes.
This
Bulls.
is Directly bulls.
Bulls. Executive summary. Next page. 53. I think all these are bulls.
Yes,
54. 54 also bulls.
Yes.
Biting a bull's tail. Twisting a bull's tail.
yes.
Poking bulls with knives and sticks. Up to 56, all are bulls. Forcing bulls to move sideways. 57, forcing bulls to stand in their own ways. 58, spectators beating and agitating bulls. up to page
59 injuries and deaths. Jallikattu is
Bulls.
there is not only to bulls.
Bulls.
Yes, sir.
Jallikattu is bulls.
Bulls. Conclusion bulls.
Okay, bulls.
Page 59.
You have said something
59.
about buffalo.
Yes.
I think this is all bulls.
59.
Ah,
Conclusion, kindly
page
see.
68, page 68.
No, kindly see 59 for a moment. See kindly conclusion. Bulls are prey animals. According to animal behavior studies, bulls adopted flight or fight response when they feel frightened or threatened. This instructional response to the perceived threat is deliberately exploited by Jallikattu organizer. During Jallikat, many animals are observed to engage in a fight response as they run away from people when they experience pain or fear. This fight response is not surprising given the amount of pain and terror bulls are subjected to before, during, and after Jallikattu. Bulls are beaten, poked, prodded, harassed, and jumped on by numerous people. They have their tails bitten and twisted, and the eyes and noses filled with irritating chemicals. Many peer-reviewed papers demonstrate a link between the action of humans and the fear, distress, and pain experienced by animals. Research has shown that rough or abusive handling animal compromises welfare by increasing an animal fear of human bulls who are pushed, hit, prodded, and abused in Jallikattu suffer mentally as well as physically. I can show before your lordship,
No.
demonstrate.
No.
No, demonstrate that same exact what is in so far as here is concerned, my lord, the events which take place. I'll show it while I demonstrate.
Those observations might be applicable.
Yes.
So far Jallikattu is concerned, it is specific to bulls. Otherwise, but same things may be applicable in
Yes,
case of
yes.
buffalo fight.
Yes.
But so far, all this research work or all this observation in Jallikattu case is in respect of bulls.
Maybe.
Maybe.
Maybe bulls. Maybe
We'll
bulls.
try to find out
Yes.
whether the pattern or behavioral things
Yes.
are common with bull and buffalo. But so far, come to page 68. Maharashtra is also bullock cart race.
Page
68.
68.
Maharashtra bullock cart.
Yes. No, yes.
Judicial evaluation. We'll see about prevention of cruelty to animals act,
Yes.
but okay, page 75. Performing animals. All animals are anatomically designed to be performing animals. Okay. All animals are not anatomically designed to be performing animals.
Keep 34 minus bulls, therefore, you cannot be
Performing animal. There is a clear finding.
autonomically not designed for that, but are forced to perform, inflicting pain and suffering in total violation of section 311(1), chapter 5 also deal with performing animal, 22 of PC Act, place restriction on exhibition training of performing animal, which there's a under.
Any specific finding of any authority as regards buffalo?
Buffalo, the finding? No, you have given a note.
That
Where is
buffalo is not,
Where is that? You are your own.
because para 33,
Yes,
there is an observation regarding horse.
yes.
Please see para 33.
33, yes.
There is an observation.
Horse on the other hand is
Ah.
a solid hoof plant eating quadruped with a flowing mane and tail, domesticated for riding and a docked animal. Horsepower, we call it as an imperial unit of power equal to so and so. Horse autonomy enables it to make use of speed and usefully used for horse racing, etc., unlike bulls.
So horse is somewhat different.
Different.
They have
But
differentiated.
I will say, suppose today your lordship says bulls, you cannot equate bulls with buffaloes.
I
No,
cannot
no, no.
see.
That's what your, well, prima facie, I am saying, prima facie. That's what your lordship observed. That's your lordship observed.
No, we say
Bulls and buffalo.
my tentative view maybe they are two species
Yes.
out of the same genus. But whether bull is equated with a buffalo, that I don't know.
Now then suppose it is not equated with buffalo, then your lordship will say, okay, 40, that notification, gazette notification will not apply. That's what your lordship, gazette notification page 41. Which
Maybe,
a
maybe.
cabinet, no, that's what, let's say, my lord, that it is not applicable. That it is not applicable. Then what happens?
Anything with buffalo in the Supreme Court judgment? Any mention? Any mention about buffalo?
My lord, there is no mention. We are mentioning it before the court for the first time. We are mentioning it.
No, the task could have been easier.
Where is that? Karnataka is buffalo. You show me Karnataka is buffalo. 41. My learned friend is showing para 41. 41.
There are 41 page.
Page 146. Para 41.
146.
So you show me where is that buffalo? Show me where is buffalo. One second. My lord, will kindly see 41, paragraph 41. 41. Our decision of a Tamil Nadu Amendment Act would also guide the Maharashtra and Karnataka Amendment Act, and we find all three amendments act to be valid legislation. Now, if your lordship kindly see, Bullock, my lord, buffalo, it's where lordship will find Prevention of Cruelty to Animals Act 1960. Kindly look into it, my lord.
1960.
1960, and the fact is, where is the convention? Two amendment is state amendments. That
Okay,
is,
okay, okay.
section
1 minute,
two
1
is-
minute, 1 minute, 1 minute.
Section two. Section two. Section two. Huh? Amendment. हाँ, definition भी आते हैं prevention of cruelty.
What did we find in this
One.
scientific, all these scientific name?
One.
That picture?
No, I just want to show, my lord. Who does
It shows that bulls are untested adult
Ubalina.
males of the species Bostorus, and buffaloes are large cattle-like animal belonging to the subtribe Bubalina.
And this is Bosporus.
Yes.
Coral white sea marker.
My lord, we kindly see this, my lord. I am holding this.
Okay,
See this?
I am having
Yes. See this state
Page.
amendment Karnataka. State-
page.
No, I don't know whether your lordship.
Section to
This is definition, section two, my lord. In section two, after they have inserted, they brought that amendment. See, section two,
2.
statement object, definition two, then state amendments, my lord will kindly say
State
state amendments. State amendment, lordship found. How the amendments are brought? I think your lordship is holding 2023.
Oh no.
2000, this is 2020.
Hey, no, don't even-
This
No.
is when, my lord, your lordship is holding which year?
2019.
My lord will kindly see this about asylum. See, I've just marked it because your lordship wants to know buffalo, like. Where is buffalo? Buffalo is not in. Yes. Page 97, kindly see. My lord, forget. Judgment, kindly see. It is in a judgment. Page 97. Page 97. 97 of the judgment. DD. on the top. Kindly see DD Kambala means the traditional sport event involving buffalo's male. Buffalo's male race normally held as a part of traditional culture in the state on such days and places as may be notified by the state government.
So what was the observation as regards Kambala?
Yes. No, my lord, they cured the defect. When it went to constitutional bench, challenging that, my lord, they took the assent of the president. Kindly see that, my lord. At page, my lord will kindly see now, at page 40, 140, it start from 140, my lord, 140, now 30, 142 kindly be looked into it, would be clear. 142, my lord, will kindly look into 142, constitutional by judgment. After, my lord, this Nagraj, it was placed before constitutional bench because there was an amendment which has been made. They cured a defect and the Nagraj said you can cure the defect, but you have to take the assent of the president. Kindly see 142, my lord, para 39, that will be cleared. 142, my lord.
Yes.
In the judgment of A. Nagraj, division bench of this court, while examining the claim of the petitioner, held that Jallikattu is dangerous not only to bull but also to human, and many participants and spectators sustain injury in course of such event. So far as human beings are concerned, their injuries would attract the principle of tort known in common law as voluntary non-fit injuria. In the light of 40 now, in the light of what we already discussed, we answer the 5 questions referred to us in the following terms. 1. The Tamil Nadu Amendment Act is not a piece of colorable legislation. It relates in pith and substance to entry 17 of list 3 of 7 schedules of the Constitution of India. It minimizes cruelty to animals in the concerned spots, and once the Amendment Act, along with the rules and notifications, are implemented, efforts the sports would not come in the mischief sought to be remedied by the section 311(1)(a) M of 1960 Act. Number 2, Jallikattu is a type of bovine sports, and we are satisfied on the basis of material disclosed before us that is going on in the state of Tamil Nadu for at least the last few centuries. This event essentially involves a bull which is set free in an arena, and human participants are meant to grab the arm to score in the game. But whether this has become integral part of Tamil culture or not requires religious, cultural, and social analysis in greater detail, which in opinion is an exercise that cannot be undertaken by judiciary. The question is whether Tamil Nadu Amendment Act is to preserve the cultural heritage of a particular state is a debatable issue which has to be concluded in the House of the People. This ought not to be a part of judicial inquiry, and particularly having regard to the activity in question and materials in the form of text cited before us, both the petitioner and the respondent, this question cannot be conclusively determined in the writ proceeding. Such legislative exercise has also been undertaken, and Jallikattu had been found to be a part of cultural heritage of Tamil Nadu. We would not disturb this view of the legislature. We do not accept the view reflected in the case of Nagraj. Performance Jallikattu is not a part of cultural heritage of people, state of Tamil Nadu. We do not think there was sufficient material before the court coming into this conclusion. In the preamble to the amendment Act, Jallikattu has been described to be a part of culture and tradition of Tamil Nadu. In case of A. Nagraj, the division bench found a cultural approach unsubstantiated and referring to the manner in which the bulls are inflicted pain and suffering. Division bench concluded such activity offended section 3 and 11(1)(a) and M of 1960 Act. Even if it proceed on the basis that legislature is best suited branch of the state to determine if particular animal sports are part of cultural tradition of a region or community or not, if such cultural events or tradition offend the law, the penal consequence would follow. Such activity cannot be justified on the ground of being part of cultural tradition of a state. A. Nagraj, the sports were held to attract the restriction of section 3 and 11(1)(a) M of 1960 Act because the manner it was practiced. The Amendment Act, read with the rule, seeks to substantially minimize the pain and suffering and continue with the traditional sports. Amendment having received, now kindly note down, presidential assent, we do not think that there is any flaw in the state action. Jallikattu as bovine sport have to be isolated from the manner in which they were earlier practiced, and organizing the sport itself would be permissible in terms of Tamil Nadu rules. So this is in respect of Jallikattu because they took the presidential assent. My lord, assent has been taken. So it is on repugnancy to 254, my lord. Now kindly see, Tamil Nadu Amendment Act is not a peat and substance to ensure survival and well-being of the native breed of bull. The said act is also not relatable to Article 48 of the Constitution of India. Incidentally, impact of the said amendment act may fall upon the breed of a particular type of bulls and affect agricultural activities. But in peat and substance of the case is relatable to entry 17 of list 3 of the 7th schedule of the Constitution of India. Our question to this, our answer to this question is a negative. In our opinion, Tamil Nadu Amendment Act does not go contrary to Article 51 AG, 51H, and is not violate the provision of Article 14 and 21 of the Constitution. Tamil Nadu the Amendment Act, read along with the rules framed in this behalf, is not directly contrary ratio of the judgment in case of A. Nagaraj and judgment in the court delivered on 16 November 2016, dismissing the plea for review of A. Nagaraj judgment, as we are opinion defects pointed out in the aforesaid suit judgment have overcome by State Amendment Act read with rules made in that behalf.
Mr. Das,
Yes.
so far these two repetition regarding Bulbuli fight and this can be examined.
Yes.
Since you are pressing for that IA also,
Yes.
I think some order might be required in that IA.
Yes.
But if we go issuing notice today, it will be difficult to again list it.
Yes.
Let this repetition be listed day after tomorrow, and we can pass an effective order so far as the IA is concerned. Because that appears prima facie against the SOP and
Only what your lordship kindly just it's my submission. Ultimately, they will not do against the provision of this 1960 Act. And they, whatever organizer has to take permission from the government, that they should ensure, my lord.
no, did you lodge any complaint somewhere? Did you lodge any complaint somewhere?
No,
In,
no, this
in
is-
respect of the matter
No, we
relating
came-
to the IA.
my lord, these organization is very difficult to find out where events are going on in the
No,
entire.
no, you have
state of the
annexed.
So we
one
have
particular-
somehow we got it one. How many events are going on? That also very difficult to find out all over the state. That's the whole difficult, my lord. Our people
Mr.
have
Das,
to.
it is also difficult to pass a blanket
No,
order.
I am not saying, my lord, I will not ask something to do which is
So,
illegal.
whatever is brought to the notice of this
what I
court
saying-
by the IA,
I am not.
so far as that issue is concerned, whether any complaint
what-
is lodged somewhere.
No, I am not saying no lordship will pass. What I am saying that they will not hold any event without the permission of the state government. That's what I am seeking, my lord. They will not. This organizer cannot do it. They have to make an application. And if the SOP says that it is only in so far as bullfight.
Mr. Das, question is committing an offense. One part is committing an offense. The next one is violating the SOP. Right?
Yes.
There are two things related to a, suppose, buffalo fight. If somebody, some committee, say Bihu committee, has organized a buffalo fight somewhere in interior place, right? That is clearly an offense without any permission, plus in violation of the provisions of prevention
Of cruelty and
to
wildlife.
animals act, right? That is clearly, that will be clearly an offense,
But
criminal offense.
But
Holding a thing.
if there is no order from any judicial order is not there.
No,
They will go on.
you have
doing.
to, no, Mr. Das, you have to prepare a ground for passing a
But
judicial
only- no, I
order.
know, but judicial order, your lordship will keep in mind the notification. And your lordship will ensure, they will give a direction, they will ensure. Well, the state is there, my lord. The government has to ensure, my lord, for the court, we will not do it. Let them give an undertaking that they will also take compliance of this, my lord. They themselves have stated that these are the period. That's only my limited submission before lordship, my lord. Your lordship will take the IA, absolutely no problem, my lord. At least, my lord, government will ensure, my lord. No such event is being taken place anywhere in the state, my lord. They have to come with an application. Government has to allow, my lord. Where is that? And government himself is saying in the SOP that this period has been 15 to 25th of January. And my lord is saying no module shall be allowed any time of the except the period. My lord, you kindly see 43, my lord. 43, my lord. Once again, I'm troubling your lordship, my lord. Once again, 43, kindly see, my lord. 43, my lord. Sorry to trouble again, my lord. Kindly see, my lord.
This Hatigor Singimari, where is located? In the IA, proposed IA, where it is located, Mr. Hatigor Singimari, Assam. Where the authorities can go and find out, even if some order is passed in the IA. Mr. Das, we will be examining it. This is a case of importance. I'm
Yes.
saying about stopping.
Yes. Well, if
We cannot,
But if Lordship allows,
My
I
lord,
have to-
we do not pass any
No, I don't
infractious
want,
writ.
my lord, I don't want that your lordship will pass a haywire order.
No, that
My
is
lord,
what
this is
we are concerned with.
See page 43 last, my lord. No, that's PC 43 last. If any organization committed for violating the disciplinary mandate, events shall be banned for next 5 years. This shall be both buffalo fight and bulbul fight. Only at a place where both fights have been traditional conducted last 25 years. I don't understand, my lord, why the government is not coming forward and saying we'll ensure it, that these events are not being taken place. We'll definitely keep in mind. Why they are not giving an undertaking before the court, my lord? Why your lordship is troubling? They should come themselves, okay. SOP says we'll ensure it and nothing, this type of event doesn't take place. They mentioned the
Mr.
date.
Das, see,
But I will.
IPC
But
lays
I
down,
will-
IPC lays down 500 offenses, right? Offenses are being committed. Just because state has, our parliament has passed an act saying that this will be an offense. Prevention of one thing, punishing a person committing an act is another thing. Now, prevention, all these offenses have been laid down. Prevention of cruelty to animals act are passed by the parliament. Offenses are mentioned there. This SOP also mentions some.
I'll just give a reply. This been tested by the apex court, my lord. Tested by the apex court, and 3 of the states said they have done it and they have taken assent of it. That's absolute, my lord.
Now, what you are saying, testing the SOP on the legal parameter is one. And second part, which you are saying about implementing it.
So today also.
That is
No,
what
today also, on the face of it, my lord. On the face of it, my lord. On the face of it. Where is that, my lord?
even to pass any order in the IA also, there is scanty material to say that where do they go? Mr. Das, DJ Das, Hatigor, Singimari, Assam. Where can I ask this? Which district administration I would ask?
Hemaji,
There is nothing in the IA. I have see to pass that to deputy commissioner or to any authority that go and please check whether this kind of event is being organized. See, to pass an order also, it has to be an effective order. Mr. Das, we are also concerned with that. This SOP is to be tested. That is one matter.
bring it ahead.
Why you are not giving, this is district Kamru Metro, whatever, that is different thing, but there is nothing.
You file it. If they doesn't understand, then come with it.
So far this is concerned, how to pass an order? That all the 35 district commissioner, please check where is Amguri, Hatigor, Singimari Pothar. It is difficult. Yes, Mr. Das, this is a matter of importance in the repetition, Bulbuli fight and Buffalo.
If I would have for the government, I would have ensured from my word that we will take it from our side that no event should take. Beyond that, I can't say anything, man. Is I leave up to your lordship, man. It's the government duty to tell that this is what will ensure. Because by way of my SOP, we have said 25th. It's up to them. If it doesn't want, then your lordship can also help it because it is not been specified. I also understand difficulty of your lordship, man. I also understand, my lord. What difficulty your lordship will face, I also understand, my lord.
Yes, is there any organization concentrating on buffalo, researching on buffalo?
We can find a, we can place a research, it's a different thing altogether.
Because we are not experts.
Oh, yeah, of course, my lord. Only.
There bull, sorry, buffalo. Buffalo, one thing is sure that it is domesticated as well as wild. Madam, you are from this organization.
Yes, yes.
Okay, buffalo can be wild as well as domesticated, right? Whether somewhere says research paper that buffalo is not a performing animal. It's not a performing animal.
So we'll place,
Huh?
we'll
Be-
place scientific.
Because I have to have some.
No, I understand, my lord. Fully understand, my lord. Your lordship has balanced it both these sides, my lord. It's not that one side your lordship, I will never.
One side, SOP says it is a culture right from the Ahom kingdom days.
My lord, yes.
Maybe the research. And
Yes.
Supreme Court has
Tradition.
washed off its hand. Right?
Let of Lord put so.
That I cannot now.
When I
See
when
the
I've seen the Supreme Court.
Supreme Court sees that it is a traditional thing. Let us, legislature has found out. So let us
My lord,
not go into that in a read proceeding.
Yes, assent of the president, my lord, your lordship will not say
See,
so many
sir.
words, my lord. My lord, we can say, my lord, but my lord, see, my lord, the assent of the president has been taken, and that has been with great respect to the
Right.
Supreme Court judgment that has not been dealt. Now your lordship has to enter into that area, and I have to distinguish what type of sports they have organized.
Yes, because all these judgments that Nagaraja,
Nagaraj.
that is specific to bull. Right. And Supreme Court in the Nagaraja, I think, stopped it.
But these are
Stopped it. Then states brought out legislations and got assent of the president. Right. Under, I think, 254 perhaps. 254. 254 they got the assent of the president. Then again matter was placed before the Supreme Court. Then Supreme Court said, oh,
Take the assent.
Parliament has
One.
or the legislature has found that it is a heritage, something like that. Will not go into that proceeding, and they have accepted the position.
My lord, today, if your lordship looks into the judgment of Supreme Court and your lordship finds out that this notification was totally inconsistent, but they have to bring an act, then even then, my lord, there is a case. Prima facie, as on date, I have a case, my lord, unless they doesn't bring it. So any event,
As on that, both sides have a case.
no, any event they held, my lord, that is will unconstitutional. How they
Because
can held it.
41 does not say also.
No, let
yes,
us
41.
forget. Let us forget for a moment 41. So what is Bulbul fight?
Okay,
my
Mr.
lord?
Das, I think we have done, let it be listed day after tomorrow with the IA.
If I
we
am
can
not
pass-
there also, I will not be there. My learned friend, I have addressed it. My lord.
No,
Your lordship
we-
will
we-
take, I have
we-
addressed it.
no.
Only that will be.
After passing some order in respect of the IA,
Yes.
we'll issue notice in these
Yes.
two cases.
Yes, but only what I pray, today I am praying, if I am not there also, that your lordship will please look into it, because that's what they are trying to do it. And my lord, bypassing the provision of the constitution, you can't do it. Number one. Number two, how you can go beyond this particular, the SOP which have been issued, and whether any letter has been written to you regarding holding of these events.
I think there was a previous litigation.
Yes, yes. This is why the previous litigation. I
Page,
tell you.
page
My lord,
157,
why this previous litigation?
page
Because
157,
of A. Nagaraj,
Page?
my lord.
157,
My lord,
the
I
order
tell your
starts.
lordship. Because of A. Nagaraj, there was a ban. This ban was put to challenge. And there was no stay except in Bulbul, my lord. Then when the notification came up, SOP, then they said that these have become, these your ban, WT message ban has become infectious because of SOP.
How the previous petition ended?
Matlab they-
Previous ended because of the SOP, because that ban, my lord, by a notification they brought it by WP message about the ban because of the A. Nagaraj. Now the government issued an SOP So
Why?
while dealing the matter by the learned single judge said, no, there is an SOP issue. So ban.
No, why did he observe? Why did he observe?
Yes,
Malak,
yes.
Malak, page
Kindly see.
Regarding SOP, SOP is of which date?
Yes,
Yes.
SOP is of
27/12.
12. Where is that?
Kindly, Malak, kindly.
7/12, the writ petition was disposed of when?
My lord, will kindly see.
No, it
It
is
is
before that.
12/12. Malak, in fact,
When is
the
the
honorable,
order?
Malak, the court has allowed them to go ahead with that. Malak, page 160, kindly see. Malak.
It's Bulbul in Bulbul Pai.
160,
Page 160. Lordship,
60.
60. Para starts from paragraph 4, 159. Kindly, Lordship, if Lordship may kindly see Malak, the 160.
160. Which
160.
line?
My lord,
Malak,
will-
Okay,
accordingly,
but if the same is done under the supervision of
I got it.
suspension.
Accordingly, the court has informed-
As the enactments providing for Jallikattu in a restrictive manner had been upheld by the Supreme Court, we cannot say the submission of Mr. B.
accordingly, the
Chaudhary
court has
under
informed.
restrictive and supervised atmosphere of the state and the state allows, so such an event can be allowed to take place. According now,
Yes.
by our audio, we require the chief
I know.
secretary to take a decision in the aforesaid aspect as the matter may be an interdepartmental one. Accordingly, the court has been informed by communication of the so-and-so in the Home and Political Department in reference to the earlier orders of this court in the present place. A meeting was held by the Supreme and the views and opinions of so-and-so has been taken obtained and file has been placed before the competent authority for the matter before the cabinet for a decision to be taken. Another communication of the joint secretary so-and-so has been produced. Orders has been placed before the cabinet in its meeting and the cabinet has approved the proposal and meeting is cleared of being declared whenever paper was placed before the court as a consideration.
No, I.
Provide specific information that cabinet has approved the proposal as regards prevalence of the year of the view matter is not required any further consideration. We require the authority to complete the process and bring the same to its logical end by the decision of the cabinet. It has to be done at an earlier.
Page 160. Page 160. 160.
Cabinet decision may be taken till now.
Buzurg
Will over any other earlier orders.
160. Page 160.
Or they may make application seeking permission. Okay.
160.
161,
Yes, 161.
paragraph 7.
Yes, para 7.
Cabinet decision that may be taken shall now prevail over any other earlier orders as regards not allowing buffalo fights during Bhogali Bihu Utsav, and the petitioners or any other intending organizers may make their applications seeking permission. The authorities shall consider such application as part of cabinet decision that may be taken. Okay. So we'll have to taste this cabinet decision, that is SOP.
So,
If you
this,
see it, my lord, so far as, one part is about buffalo. Next part is a bulbul fight. Bulbul fight, which is lordship kindly see the next case, that is 468. 468 of the notification. Notification at page 38 now, that is 468. Wait petition.
Page?
Page 38 of that same SOP. Now see kindly last portion, background of Bulbul birds fight. Although there is no documented history about when Bulbul fight started, old times say it was started by great Ahom king Swargadev Pramata Sinha during his rule between 1744 and 1751. People believe that the king saw two Bulbul birds fighting while descending the stairs of the temple. Thousands of people from across Assam converged on the town of Hajo in Lower Assam, Kamrup district, to witness the famous Bulbul takes place during Bhogali Bihu. Bhogali Bihu, birds fight in sea, so and so Mandir, Madhavdev Mandir, Hyderabad Madhavdev Mandir, precise premises, kept a ban order dated 13/1/2015 abeyance until further orders. So these are the SOP. Kindly see next. My
What
lord,
is page
page
39, first line?
This is complete.
This is full or what? This SOP is complete.
This is what my instruction is complete. Sure.
Because
Yes, some is missing, I think.
something is missing
One
here.
is missing.
One line it is complete. Some one page might be missing.
One line is missing, I think.
Hmm?
Bottom line.
No, celebration every year.
Bottom line.
This also somehow out of place. Page 39, first two lines,
Yes.
looks like it is out of place. Something is missing.
Yes.
Page 39, first
Please find
place.
it out.
There is no
We'll find out.
reference
No, we'll ask to find it out, my lord.
how this has come.
Yes, yes, yeah. We'll find it out, my lord. And the SOP,
Okay, it is definitely required to be tested.
yes, yes. SOP also, my lord, is thereafter.
Well,
Page
They
13.
may come up with
as regards-
history, I don't know.
as regard testing the SOP, Lordship has, that Lordship will do. And as regard in the other Buffalo, the IA, I have said that I'll take the.
Mr.
instruction
Das
on
will
Friday.
give you a copy
Yes, yes.
and also the location, though
Yes.
nothing is mentioned in the location.
Yes, sir.
You
That-
just take instruction about
That,
that.
Manoj,
Whether somebody is organizing something on court,
yes, without
some
instructions.
buffalo fight,
Yes, I'll take the
then
instruction.
we can see that there has to be strict observation.
But
observance. So
in fact, the SOP number 1, I have
So
indicated.
far as the SOP stands,
Correct.
it should be strictly in adherence of the SOP.
SOP.
And if the SOP ultimately goes, everything goes.
But
Yes,
SOP,
yes,
my lord, SOP as on date, prima facie doesn't stand because of they have not made any amendment. That's how they can issue an
No,
SOP.
at
my
this
lord.
stage,
All
Lordship
those
may
things-
not-
That
Yes,
will
Lordship
say.
may not-
Judgment, all the judgments of the Supreme Court Constitutional Bench of 3 states has made an amendment and they cured the defect.
Mr. Das, that is why I am asking you to very pertinent question that whether bullock and buffalo can be
Bull
considered,
and buffalo.
or bull and buffalo can be considered as identical. And second, whether this buffalo is not a performing animal.
But in respect, Kamala, my
Show
lord,
me some authority.
I've shown an authority, my lord. Kamala is about Karnataka. Kamala is regarding buffalo. That I have shown your lordship, buffalo. Even
Where
the-
does the observation?
No, it's not an observation. There are 3 acts
Oh,
which have
Mr.
been
Das,
amended.
that they have amended.
They have amended.
Hearing that, but so where is that that they are not performing animal? These two questions. Show me something, because all these are related to bullock. Yes, Karnataka Kambala or something.
Yes.
But whether those notifications, what is the background of that act? Because authority says that buffalo is not a performing animal. And that is why we need, because of tradition or history, there is Kambala, used to be Kambala. So for that, we need a legislation under 254, Article 254, to get the presidential asset.
They have not done it. Insofar as bullock.
No, where is the,
Buffalo.
to deal on that aspect, on the motion day, you have to show me.
I'll show it. Please
That-
fix it. Please fix this matter, then I'll show it. I'll show it.
Day after
I will
tomorrow.
say that SOP should be state. What a bulbul also should be said. I will show how it cannot be performed under the act.
So show
They
me
hunt-
performing
My lord,
animal.
Bulbul, they hunt and they capture. Kindly see, my lord. Kindly see bulbul, my lord. What they do it, how it is violated.
23. This is 21.
Where is my wildlife?
Mr. Das, you will not be there tomorrow or day after
I
tomorrow.
am not there. My lord. That's the whole point.
Lordship may keep it on Friday or not. Tomorrow is a holiday.
Friday available?
Tomorrow is a holiday.
No, no, day after
On Friday.
tomorrow.
Friday.
Day after tomorrow? Or Mr. Das will be available on Friday?
These 2 days, my lord, only.
Because according to the
Please,
IA,
my lord, kindly.
they are
see the
going
act.
to,
Wildlife Protection Act, my
they
lord.
are going to held the
Wildlife
buffalo
Protection
fight on 4th, is on Sunday. That is why I have prayed for Friday.
Hmm?
According to the IA, my lord,
Yes, that is why I thought that it should be fixed on Thursday.
but
So that
tomorrow is a holiday, my lord. I have to get the instruction.
See the Wildlife Protection Act for a moment, my lord.
I need one working day. my lord.
Wildlife Protection Act.
Wildlife Protection Act 1972.
Section.
No, but see the schedule, my lord. This is schedule. Schedule 2, my lord, kindly. Schedule 2. I'll show schedule 2 first. Schedule 2, bulbuls. Schedule two.
Schedule two.
Bulbul kindly see 50. It starts from after 49
Schedule
bulbuls.
two, I think, has
Part
many
B,
parts.
Part B, birds,
Part B.
birds.
Part schedule two. Part B.
Birds,
Birds.
birds. Please go on.
1 minute. Birds.
Please go on from 1 to 49.
Schedule 1 minute. Schedule two. Wildlife Protection Act 2019. Schedule two. Schedule two starts
I
with
think-
part.
I think 2019, I think it will not be there. This is 2022 amendment, my lord.
22 amendment. It's so পুরনো কিতাব. What does it say?
My lord, it says, part B, bulbuls, if it sees at serial number 60, red vented bulbul. Red vented bulbul, it is part of schedule. And how, my lord, how the act has been dealt. See kindly, my lord, what is hunting? First C, not hunting, first C, definition, section 9. Section 9. I think that will be there, section 9. Section 9 will be there. See kindly, section 9. Section 9. See, section 9 will be there. Prohibition of hunting. Logic is there. Prohibition of hunting, no person shall hunt any wild animal specified in schedule 1 and 2, except as provided under section 11 and section 12. Lordship got it? Now, if your lordship kindly the definition of hunting, it's hunting is at 11, no? Section definition is 216. Definition at 216. What is hunting? Got it, hunting. Hunting means grammatical variation and cognate expression into killing or not killing. B, capturing. Capturing, coursing, snaring, trapping. It's a capturing. You hunt and capture, not killing it. Capture and you this event takes place. So you can't do it because bulbul, it is a prohibition. You can hunt also because you hunt and capture. So it is not a definition of hunting.
What is the show me the schedule?
Yes. My lord will kindly take this.
এখন দিয়ে দিব channel উপর. এখন দিয়ে দিব channel উপর.
এখন
Which entry?
60. 63, I think. 63. I have marked schedule 2. Schedule 2. I think I highlighted, my lord. All bulbuls, my lord, species.
When Mr. Das will be available to pass any order, it would consider the interim pair also,
Yes.
because I have to look into it,
Yeah, definitely.
the judgments.
These are important matters, my lord.
We cannot also pass any order without knowing.
No, definitely, my lord.
So far the IA is concerned, it can be listed day after tomorrow.
Day after tomorrow.
Well, so for the IA is concerned, I pray Lordship may take up on Friday.
Friday.
Because one working day kindly give me, Lord.
Okay.
Tomorrow is a holiday.
only
And
one-
so for the writ petition is concerned, Lordship, will
Oh,
Let-
let this petition be concerned, listed
let-
along with the IA on Friday,
My lord,
and we'll take up that IA basically.
Lordship.
And the repetition will be taken up as and when Mr. Das is available.
In the writ petition, kindly give us some time so that we can come up with our instruction and file affidavit. Because the SOP has been changed.
What I propose
Yes.
is that let these two repetition be listed along with the IA which has been filed.
On Friday.
Right.
Let it come on Friday.
Mr. Das might not be available on that day,
Lordship.
but we'll pass an order in respect of the IA. And we'll keep the repetition
Lordship.
for further consideration as and when Mr. Das
That's right.
is available,
Yes.
right? And Mr. DJ Das, if you get further information as regards the exact location, please bring it by a short once
My
statement.
impression was that Lordship being a cognizable offense, Lordship, the government would have.
No, petitioner has said that it
No,
is in
no,
Jorhat.
please,
Something
no,
only they said it
Mr.
is in
Das,
Dhamaji.
Mr. Das, please
Lordship, Lordship,
specify
Lordship.
that this is organized at Mohguri so-and-so district, so-and-so,
Under the-
subdivision so-and-so, at least that.
Lordship, I'll try to get the location and I'll file an additional affidavit in the IA, Lord.
Yes, so that I can,
Just a one-page additional.
I can
District only.
ask Mr.
Precise direction.
Nath to
Yes.
take appropriate action
Yes, yes.
in respect of
From
the
that
IA
administration.
regarding stoppages of the proposed buffalo fight.
Yes, Lord.
But testing the validity is another matter.
It's on.
That is
In-
altogether.
Because
different
as
thing.
per the SOP also that fight is cannot be. Because it was only up to 25th. As per the SOP, it would be illegal. So
Even
far, testing the SOP is concerned, that is another matter.
So for the testing the SOP and the approval of the cabinet.
That is one
That is
matter.
one matter, Malad. Their Lordship will give us time, Malad. We'll
Even
be able
as
to
per
respond.
the SOP,
It is not.
that proposed
Yes,
buffalo fight is
That-
illegal.
That I will take the instruction. That I will take the instruction.
So
Definitely.
we'll deal with that IA on
Yes,
Friday. And we'll keep it this for further consideration.
Yes, yes.
For the consideration. When ask her.
Heard Mr. Didas, Senior Counsel, assisted by Mr.
When is comfortable for you, tell me.
Even the year is not there. 20 mark, 20 mark. 4th
Assisted by
February.
Mr. DJ Das. Counsel for the petitioner. Same over. And Mr. Dina.
For 1 and 2, Malad.
See, 6,
Senior Government Advocate, Assam.
we tell them what is.
For the respond number 1 and 2.
That's fine.
And Mr. Animal Welfare,
Lordship, notice has to go. Lord.
Notice has to go.
I think CGC.
Oh. Welfare ko na?
It's a board, Lord.
No, we are not issuing notice because we will consider also the interim prayer.
Yes.
Not-
That is why we will keep it this at the motion stage.
As regard the interim prayer, Malad, that Malad, I am opposing that, Malad. Kindly give us time to file the response, Malad. Because the SOP now, Lordship has seen, the buffalo fight is till 25th of 25th, Malad, it is already gone. So Malad, the SOP with the approval of the cabinet and when the matter was pending before the honorable court has passed a judgment, Malad. Lordship will test it, Malad. Let us have the instruction, let us file the affidavit, Malad.
No, we are not passing an interim order.
For-
don't
for
we?
inter-
We'll
for interim order.
consider because they are asking. We are not.
We are asking for interview, your lordship may not.
Keep it in the motion stage, right?
Yeah.
You'll
I got that.
advance
I
your
got-
submission
I got that.
on the interim prayer. May pass or may not pass.
True.
That is one thing.
True. For that only, Malad,
So
I
that
have,
is, I have not gone to that extent.
Lordship.
Whether I'll pass an interim order or not, I am saying that while considering the issuance of notice, we'll also consider whether any requirement of passing any interim, right?
Lordship.
So we are not issuing any notice at this stage.
Okay.
Mr. Das, Senior Counsel for a petition, has submitted that an interlocutory application has been filed in the writ petition WPC number 466/2024. But the same has not been listed today. Full stop. Mr. Mr. Nath, learned senior government advocate, has submitted that a copy of the interlocutory application has been furnished to him, and he will obtain necessary instructions in the matter. With necessary instruction with regard to the issue raised in the interlocutory application. Full stop. List both the repetition along with the IA.
Filing number is lot to 1159 of
Within bracket filing number
1159 of 2024.
comma stated to be filed by the petitioner on Friday. Friday will be too early. Oh, sorry, Thursday?
Friday is second, tomorrow is a holiday. Today is Tuesday, Wednesday
Okay,
is. a holiday.
Saturday is a working day for the investigation.
Yes, yes.
Okay.
Even if it is not working day, if lordship passes an order, I'll do that.
No, I have found in one case, despite passing interim order, it is being
No,
violated.
that
That
I-
is why.
That I will ensure, that I will ensure. During course of the day, they will get the details.
So that
Saturday,
a
Saturday.
plea is taken that due to
Non-communication.
non-communication.
That is, that,
So I want to ensure that my directions
that,
of this court is properly in.
My lord,
that I will,
indeed
that
the
I will
main
ensure.
case-
Let
main
it be on
case-
Thursday.
My lord, yes.
Well, the petitioner will give me the details by during course of the day. Lord. Which place, which
Today,
district, during course of the
my lord,
day.
he will
Today,
give you
today I will file it.
today.
Today I will send.
And secondly, my lord, the main case, so further, my lord, praying for interim, we will heard on a date, 6th or 7th, whichever is comfortable.
In the motion stays will be.
And they both-
In the
then your
motion
lordship
stays
will
will
fix it.
be Friday.
Yes,
We'll
then
pass an
my-
order in the IA, we'll keep this for further consideration, the motion stays,
Correct.
as and when Mr. Das is available, okay?
Well, since lordship has fixed on Thursday, I'll pray for Act 2 block because Thursday is just the reopening day.
Okay.
Tomorrow is a holiday.
Thursday,
2
at 2.
2 o'clock.
I'm deeply obliged, my lord, deeply obliged. Only, my lord, one request, X has to be updated in the court.
No, that has been,
No, no, but-
already,
know,
purchase
I'm
orders have
sorry.
been placed.
I tried to carry 2 books. Today I have not carried 2 books. now.
No, purchase orders have been placed.
My lord, one thing, when we were walking with PK Goswami, then he said, carry also 2 books. One for the court.
I
one
used
for
to
your-
carry.
2 books.
I used to carry,
2 books.
and
Same book, same pagination.
one matter was argued for many months. And ultimately, judgment was delivered. Thereafter it was found that a particular amendment was not brought to the notice of the court.
That's the excise matter.
No,
Yeah.
something else. And it was not brought to the notice of the court. But whole controversy was resolved on that point. And that section has been amended in the meantime. Matter was argued for months.
I couldn't carry this book, 2 books. Normally I carry it. Deeply obliged.
Number 1 to 3.
Yes.
Go ahead, please, sir.
Yes.
My lord, in
Let us-
item number 1, my lord, unfortunately, my petitioner died on 30 January, man. So we need to change, my lord, secretary, he died, my lord. So we need to file IA, my lord, appropriate, incorporating somebody else, either president or some new secretary.
Okay, who are the other interesting parties?
Same,
Huh?
Secretary Murile bhai. Gompi sir.
Mr. Borbe, you appear for item number 1
Item number 1, man.
as a petitioner.
Same challenge করেছে।
Mr. Dotto, you appear
না,
in item number 2. And who appears in item number 3? NG Kundu? Huh? 2 and 3.
or three.
Now, Borbia says that he is handicapped.
Yeah.
What to do?
Yes, to substitute.
I have to
Okay.
substitute.
I hired Mr. J.I. Borbia, learned counsel for the petitioners in WPC, item 1. And Mr. M. Dotto, learned counsel for the petitioners in item 2 and 3. Also hired Mr. Dizemin. Dinath
I'm for the
Learned
state.
Senior Government Advocate Assam for the state respondent and Mr. DJ Mehdi, Learned Counsel for the private respondent. First of, Mr. Borbhuya, Learned Counsel for the petition has submitted that a necessity has arisen to substitute to make substitution. In first of, he has thus prayed for
My lord,
substitution of the petition.
petitioner died on 30 January, my lord, that may be reflected.
13
30, 30.
Azi 30.
Azi 30. So,
Huh?
3 din out of. Recently, man.
Okay.
Oh, sorry,
Substitution
30.
of the petitioner. First of, he has thus prayed for listing of the case. When can you do?
Lordship, date may be fixed, my lord. By this time, we'll do all the process.
Yes, tell me.
It says settlement process, my lord, in the second week, if possible.
Okay.
Lordship will fix the matter, my lord, on
16?
16
not-
Friday, my lord.
Not on 16, my lord.
On 20th, my lord, 20.
20?
20.
20.
Okay. Okay. And to enable him to file appropriate pleadings for substitution. First of, the learned counsel for the parties have submitted that the cases be listed in the on a date in the week commencing from 19th February 2024. First of, list the cases on 20.
Items 4 to 9.
In this particular case, my lord, I have challenged, my lord, my Patta land, my lord. Actually, my lord, was taken away in the name of, my lord, a government school, my lord, model school, my lord. And my lord, when the construction started, we came to learn, my lord, that they are relying upon some relinquishment letters issued by us, my lord, which we deny, my lord. In fact, what has happened, my lord, there is one of the allegation was, my lord, that even deaf people are also named in that, my lord, so-called relinquishment letter, my lord. I have, my lord, I had, that is there. I have got the death certificate which I could not annex earlier, my lord. So, my lord, otherwise I was ready for the hearing, my lord. But then if I would like to bring that on record because that certificate will show, my lord, one of the persons, my lord, was already dead, my lord. His signature was taken and to be, my lord, they're saying that part of the relinquishment, my lord, process, my lord, where all the people are relinquished. His name is also there. His signature was also taken. And this person died in 1919.
What does Mr. Majumdar say?
He wants to bring on record something like someone has died. Let it be done very early because this is a matter something
Next time, my lord.
for the benefit of the local people where there is only one college. A degree college was sought to be established on the land. We have got records. All of them have given the land as they have relinquished their right over the land for the purpose of enabling the government to construct a building for establishing a degree college, model degree college for the benefit of the people. Now they are coming forward saying that no, we have not signed it. All these records are there. And earlier on 25th of January 2023, Lord, you kindly see, an order was passed
25th of
January
2023.
In fact, prior to that one, if your lordship kindly refers to the order dated 8/9/2022 in 9/1 IA
8/9
8/9/2022. Right.
in which WPC?
My lord, in my lord, WPC, my lord, my lord, it should be the first order of the case, my lord. 9 months, my
It
lord.
started
941.
tag together.
But all these petitions will raise a common question of fact, law and fact, my lord. 8/9/2023,
Which order?
8/9/2022, my lord.
8/9/2022.
22, my lord. It should be in the my lord, first petition itself, my lord. That is 941, my lord.
8/9/2022.
2, my lord. Because the matter was heard at length, my lord, and then, my lord, they proposed to, my lord, give us.
8/9/2022.
Yes, my lord.
Which writ petition?
My lord,
This was in the IA. Well, I'm just referring it not for the purpose of saying that it should go to there, but not on there. What I'm saying is, my lord, this order was passed perhaps on the, I'm not sure whether on the, I was not there, on the impression that the land people cannot relinquish their right over a land. You should acquire the land. Now, Assam land and regulations made specific provision in the settlement rules that one can relinquish his land.
What is the manner of relinquishment?
The application has to be made before the deputy commissioner.
No, volume 1. Settlement rules,
My lord, settlement rules, 24.
20. Resignation.
My lord. If any settlement holder wishes to relinquish the whole of his estate or any entire fields, lands within his estate, he shall, after paying all the land revenue due from him in respect of the estate or fields proposed to be relinquished, tender a written petition to the deputy commissioner or other officer empowered in this behalf. The latest date for filing such petition shall be 15th February. If the latest date falls on a gazetted holiday, petitioners for relinquishment may be tendered on the first opening day after such holiday. This is there. And then next rule 77, Lordship may kindly have a look. Relinquishment. The provision of Rule 24, which I have just now read, my lord, shall, so far as may be applicable, apply to townlands also. So, under these two provisions, my lord, relinquishment is permissible. And possibly, I am not sure, possibly the earlier order that was passed on 8/9/2022, based on which the.
I have not got the 8/9 to 2022 order, which. Okay, maybe 1 minute. There are few other orders.
In fact, my lord, it should be in the main writ petition itself because my lord, this honorable court wanted to dispose of the matter, my lord, on that day. Then, my lord, the state, rather the education department came up with a plea, my lord, that they should be allowed, my lord, to explore.
In all the writ petitions that was passed.
Yes, my lord.
8/9/2022.
It is in IA, but in IA is in connection with all the petitions. And Lordship may kindly have a look at this, or this order will clarify.
Because it is not in the first
May
part.
not be there, madam. It may be there in the IA only.
Well, not in item number 4, my lord, in item number 5 onwards. 4, my lord, I don't know how it has been tagged, my lord. 4 is something different, my lord. 4 was not initially there in the list, my lord.
Now,
WPC, my lord, 3, sorry, WPC number 9.
Which part?
317.
which part of the entire order is based on the possibly impression that such relinquishment on the part of the settlement holders is not permissible, and state must either acquire the land or otherwise purchase the land in order to undertake this kind of scheme. My submission is today, your lordship may not enter into all these things. What our our anxiety is, this is a time-bound project. Within March 31st, if this is not executed, then the scheme for the next year, the financial grant for the next year may not be given. And other villages where we are thinking of setting up such model degree college will suffer. If they are not interested, we'll just withdraw, my lord. If they are not interested, we are not going to acquire the land. If they are not interested in such model college, we'll withdraw. We'll not do it, man. So that way, this requires early disposal before March. This has to be disposed.
I just pay for week's time, my lord. I'll just hurry. Because
Let him have a
this
time.
this documents, my lord, came to me without privacy.
We wanted to have a degree college there so that it's for the benefit of the people. Those people who are interested, we have got records to show that they have put signature, they have given the land. Now, some of them are saying that no, our signature was taken by forging our signature. Others are coming with.
Okay, that is one thing. But obtaining a signature of a dead person is another thing.
If that is correct, there is another thing. What I am saying is, my lord, a
Yes,
building was coming up after certain step, suddenly.
There could be a possibility of that after signing it, they are making an U-turn. That is one thing. But making a dead man sign is.
This is a clear case
Man
of
who died in
U-turn.
99, my lord.
My lord, this is a clear case of U-turn. After it started.
But so far as dead person is concerned, cannot be.
He died in 99, my
No,
lord.
my lord. Legal years have said that they did not sign. Now the legal years are saying, possibly they have become wise and they thought, no, let us not have degree college, let us have our own land. All right, we will not have it.
It will be it can be a possibility of U-turn. So far, that what has fallen from Mr. Doctor is concerned,
I think
that
he-
those relinquishment deed also bears a signature of a dead man.
Yes, my lord. And non-existent persons also, my lord. That also.
These two allegations are serious.
Non-existent persons, my lord.
we did not have
him
ever
bring
any intention
what,
of.
2-3 days, how many?
My lord,
You file them in time,
Yes, sir,
I
I'll
can
file.
post it
Yes,
for the convenience of
Yes,
all the
I'll-
parties.
I'll file.
It can be on 8.
Well, eight some difficulties, my lord.
Eight.
Eight, there are some difficulties. Can it be, my lord, uh,
8, 7,
eight, there are some, my lord, difficulties, my lord. Seventh, my lord.
7.
Seventh or, my lord, ninth, my lord. Ninth.
7th,
Ninth
no,
is a
if
Friday.
it is 7th, it
Hello.
can be only at 3 p.m. Those are Musondis.
Let it be on hearing then. Let it be on 13.
Let it be on
13.
15, my lord.
13 to vote get a
15, let it 15, my lord.
15.
15, my lord.
15 is a Thursday.
15.
15 we can do. Okay, the Mr. M. Doctor. You are for all?
I'm all for power, my lord. But I don't know, 4, my lord. I don't know how it has been taken, my lord. It's not been.
What is that issue? Okay, I am taking up, I am looking at the order sheets of only 4.
4, my lord, is it was it
Huh?
come later on, my lord. I don't know how it's come, my lord.
Is it not?
Similar.
4 is not related, mister?
Related, man. All are related.
All are related. Okay.
One common order will do, man.
And in fact, my lord,
Okay.
I don't know.
Mr. R.B.
RB Guhai, my lord.
Muhai, learned counsel for the petitioners in court. And Mr. M. Doctor, learned counsel for the petitioners.
5 to 9.
4 to 9.
5 to
5 to 9.
9. And Mr. D. Mojumdar, learned additional advocate general Assam, assisted by Mr. D. Nath, learned senior government advocate Assam for all the state respondents. For the state respondents are present. Most of Mr. Doctor, learned counsel for the petitioners has prayed for a week's time to file additional pleadings in order to bring certain vital documents having a bearing. So the praise allowed as sought for by the learned counsel for the parties list the cases on 15.
Right.
2.
We want,
15 2.
we want to only close the project, man.
Item number 10.
Yes, morning some prayer was made.
Lordship,
Somebody.
there is-
And you said some,
Lordship.
I have not seen the order. That is why. You take Khakulia. Mr.
P. Das, Lord.
Pidas, learned counsel for the petitioner. And MS?
M. Deca.
M. Deca, learned counsel. Representing Mr. S.C. Kyle,
Yes.
learned standing counsel. GST. For all the respondents?
Yes, Lordship.
For all the respondents are present. MS. Deca.
M. Deca.
Deca. Learned counsel has submitted that Mr. Kyle is out of station due to certain emergency and has no, you are seeking time to file affidavit or what?
Yes, Lordship. Allow us 3 weeks time.
Has prayed for and is granted 3 weeks time to file counter affidavit on behalf of the respondent authority. Mr. Das,
P. Das.
learned counsel for the petitioner. Has submitted that the petitioner has deposited The principal amount of rupees 33 lakh 69,271 in compliance of the order dated 21/12/2023. And in support of such submission, he has placed a copy of the receipt dated 12/1/2024, which is marked as text. Full stop. Mr. Das has further submitted that as the condition indicated in the order dated 21/12/2023 has been complied with. By the petitioner. The interim order passed on 21/12/2023 may be continued. In view of the submission made on behalf of the petitioner that the petitioner has deposited the principal amount of rupees 33 lakh 69,271 on 12/1/2024 in view of the statement made at the bar by the petitioner. The interim order passed on 21/12/2020 shall continue. I mean,
Lordship, we tie up to fix a date, Lordship. On 22nd of February, we keep convening.
no, let them file the counter 26. 26. Please, the case of 26.
Item number 11 for orders.
Yes. It may not be possible to conclude today, we can start. Because court will not sit after 1 o'clock.
My lord, here my contention was that Article 21 says that liberty can be curtailed only, my lord, in except, my lord, the procedure established by law, he will not be deprived of the language. No person shall be deprived of life and liberty. So here the prejudice will come later on, but whether the procedure which is adopted by the prosecution can, by that procedure, which is not otherwise authorized by law, can I be dragged, my lord, to a prosecution? Because there is some amount of curtailment of my liberty. And if your lordship goes by 166A, your lordship will find that this is mandatory. Because unless there is an order of the magistrate, my lord, the evidence cannot be collected. Notwithstanding anything your lordship has got, my lord, 166A, anything contained in this code, in the course of an investigation, and it, your lordship will kindly take note of, it starts, my lord, with a non-obstant clause. In the course of an investigation into an offense, an application is made by the investigating officer or any officer superior in rank to the investigating officer that evidence may be available in a country or place outside India. Any criminal court may issue a letter of request to a court or an authority in that country or place competent to deal with such requests to examine orally and person supposed to be acquainted with the facts and circumstances of the case and to record his statement made in the course of such examination, and also to require such person or any other person to produce any document or thing which may be in his possession pertaining to the case, and to forward all the evidence so taken or collected or the authenticated copies thereof or the things so collected to the court issuing such letter. Then 2, my lord, your lordship will see, the letter of request shall be transmitted. This is, my lord, how it will be collected, the procedure, my lord, in such manner as the central government may specify in this behalf. There is already, my lord, circular. Then 3, my lord, is also important. Every statement recorded or document or thing received under subsection 1 shall be deemed to be evidence collected during the course of the investigation under this chapter. Now, if your lordship goes by 1, your lordship will see, my lord, this provision having a overriding effect requires, my lord, that the investigating officer has to make an application before the magistrate. And the discretion, my lord, rests with the magistrate, because the language is the criminal court may issue a letter of request. So therefore, my lord, in my humble submission, unless, my lord, this procedure, my lord, is taken recourse to or adhered to, my lord, evidence, my lord, or the materials which are collected, my lord, cannot be used against me. Because here, if I say so, my lord, the Nazir Ahmed case can be brought in, my lord. When a particular thing, my lord, is required to be done in that manner, it has to be done in that manner, my lord. All other, my lord, modes are necessarily forbidden.
Yeah.
My lord, a detailed procedure, my lord, is laid down. 166A. So therefore, my lord, it is incumbent on the part of the investigating agency, my lord, to take recourse, my lord, to this particular procedure. And any other procedure which is used against me, my lord, the horse 166A, in my respectful submission, my lord, infringes upon my right under 21. And therefore, my lord, being a constitutional court, with all respect, my lord, this particular, my lord, mode and manner in which, my lord, the investigation has been conducted requires interference, my lord, from your lordship, my lord. And if your lordship goes by 3, my lord, 166A, my lord, it will be an evidence only in respect of, my lord, the materials or the documents collected under, my lord, 166A1. It will only form as an evidence, my lord, otherwise not. And if your lordship goes by, my lord, the SARS sheet, and the SARS sheet is based, my lord, on the materials which is collected from the High Commission. Okay. So in long and short, my lord, this is my respectful submission, my lord. Otherwise, I have a, my lord, recourse before the trial court, my lord, that I understand. But having regard to, my lord, the manner and
Now,
method.
let us read section 166A again.
My lord.
Now, what is the significance of the word if?
If in the course of an investigation into an offence.
If in the course of an investigation. So, what is the significance of if? All these propositions have some meaning.
Yeah.
That ifs and buts. So, if in the course of investigation.
Right.
So, how does it go with the submission you have made that this is mandatory?
My lord will tell you.
Because it is if in the course of investigation.
What I'm trying to say, my lord, this is the subjective satisfaction of the IO. If he feels, my lord, that it is necessary the IO will decide, my lord. If he feels it is necessary, that evidence is required to be collected, my lord, from outside, my lord, India, then the process, my lord, procedure under 166A has to be resorted to.
And if this procedure is followed, then whatever is collected will be treated as evidence as per subsection 3.
Yeah.
That does not, at the same time, says that any material collected in different method will be not treated as evidence. Well, legality or validity of the evidence, unless it is of unimpeachable character,
My lord, I say.
is not to be gone into
Yes.
in a proceedings under 226 or 480. Now, everything hinges on the side of the investigating authority on the letter issued by the authority in the Bangladesh something.
High Commission.
So, whether that is will be can be treated as a legal evidence or not, to foist all the charges upon you,
Well.
right? That is to be tested on the basis of whether it is correct legal evidence or not, as per Evidence Act. But here it is this if in the course of an investigation into an offense, and application is made by the investigating officer that evidence may be available in a country. So first is if, then there is to be followed by the some formation of opinion by the investigating officer, followed by an application before a competent court. Then competent court may again discussion. All are, it starts from if everything.
No, my lord, I am submitting in this manner. If I, my lord, put it in this way, my lord, obviously there is a discretion which rests, my lord, with the investigating authority or agency, my lord. Obviously, my lord. Now, my lord, if the investigating agency, if it feels, my lord, necessary to have the materials, my lord, from outside India, then the course open is 166A. That High Commission is, my lord, not permissible. My lord, here I am not submitting in respect of a evidence, my lord, which is collected in accordance with law. Apparently, the materials collected, my lord, is in conflict, my lord, with 166E. So in that regard, my lord, my humble submission is the way it has been collected, my lord, it could not have been. And therefore, my lord, that material, my lord, cannot form the basis, my lord, of the impugned, my lord, the charge sheet, my lord. Now, if your lordship see, had it been not necessary to obtain the material, my lord, if we go by this if, my lord, had it been not necessary, my lord, the investigating officer, there was no occasion to approach, my lord, the Assistant High Commissioner. So obviously, my lord, it has to be understood that there was a necessity. So if that be so, my lord, the IO ought to have been collected evidence, my lord, under 166A by filing an application before the, my lord, jurisdictional magistrate, my lord. This is my humble submission. And if your lordship sees the charge sheet, the entire charge sheet, my lord, is based on this particular, my lord, material. No other evidence at all. This material has formed the basis, my lord, of this charge sheet.
Anything?
Nothing.
First of all, also my submission is that, Lordship, this is not a 430 application, Lordship. There are other provisions, other Lordship, 482, Lordship, 482 application, Lordship. as he has, as the petitioner has challenged lordship, the entire search sheet, entire proceeding, trial proceeding lordship, they could have approached by way of filing 482 application, but passing of entire thing lordship.
What is
And
the prayer made here?
they have paid for passing of entire proceeding, search sheet, everything lordship.
Fine.
FIR, search sheet, everything.
My lord, I may confine to B and C, my lord. I may confine to B and C.
Further process.
So lordship, one thing is.
226 is
Lordship.
otherwise
That
available.
can be lordship.
That is.
And apart from that, lordship, SARS has not yet been framed, lordship, and he will get the opportunity of during the course of research hearing, lordship, regarding entire
Because
this
petition
things.
under 482 and 226 are same.
Same. That
If
is
you
same.
read Bhajan Lal
Bhajan Lal.
paragraph.
That can be.
Okay.
Lordship. But apart from that, lordship,
Cars.
lordship has rightly pointed out that thing, or that line, lordship, but lordship, that whether that can be interpreted like this, as my colleague has stated, lordship, that if the investigating officer thinks fit, it is not like that in the paragraph, lordship. It is written as, lordship, notwithstanding anything contained in this code, if in the course of an investigation into an offense, an application is made. If an application is made, it will come, lordship, in that case, lordship. It is not like that if the investigating officer thinks fit. It is not like that, lordship. If it is an application is made before, so it is not mandatory. I think it is not mandatory at all, lordship, that has to be taken. Or apart from that, lordship, there are today I am not available with that judgment, lordship. Today I thought it is in my file. Today I am not available. There is some judgment also of the apex court, lordship, where it is stated, lordship, clearly that if there is some lacuna, if there is some procedural lapse in investigation, but the other witnesses are trustworthy, in that case, the case is not fatal, will not be fatal, lordship. Case will not go, lordship. Today I am not available, lordship. If lordship allow me some time, then I can place that judgment, lordship, and that is their, lordship, specifically. Because this is, even if we admit it for a time, and that there is a procedure in taking that.
Mr. Talukdar
No, no.
or Mr. Lockor. In CRPC, provisions are there which indicates in what situations proceedings are illegal and in what situations the proceedings are irregular. Now, does it indicate anywhere that in these situations, investigation is illegal? In these situations, investigations are irregular.
My lord, I have understood. My lord, lordship is correct to that extent. But my lord, those may not be exhaustive, my lord.
Apprise me on this
I have
point.
understood, lordship's my lord purport. My lord, those may not be exhaustive, my lord. Here is a case.
Whether
If I say-
anything,
My lord, my humble submission.
whether there is any concept
My lord.
in law, let me frame the precise question. Whether there is authority has the power to investigate, right? On that premise. Whether there is any law that the investigation is to be treated as illegal, is declared illegal, lackadaisical, improper, perfunctory, unfair, biased, all these allegations are available to be made. But whether there is any concept in law that this investigation is to be treated as illegal, is declared illegal.
Yes. Then, my lord, investigation normally, as your lordship has also understood, that it is normally not my lord, challengeable. Investigating agency has done it, my lord. But here, my lord, I am on a different perspective, because your lordship will see, if your lordship is satisfied on the face of it, where argument is not necessary to deduce, my lord, that particular position, that the methodology which is adopted infringes, my lord, my right under Article 21. So in that view of the matter, being a constitutional court, my lord, I'm posing this question to myself, whether or not your lordship will interfere. Because apparently the material, my lord, which forms the basis without any other is only that material. And Article 21 is very clear. No person shall be deprived of his life and liberty except the procedure established by law. Now, this procedure, which has been adopted by them, it is not established by law. In my respectful submission, it is 166A. So that, my lord, 166A has to be taken recourse to, my lord, to drag me, my lord, into this prosecution. This is my humble submission, my lord.
Do you have any authority on that point?
I'll place that, my lord, in that regard.
That 166
Yes, because this
is
your lordship
the,
will
is
examine,
the,
my lord. Because as a, my lord,
no, no.
as a matter of fact,
Any
I'm not
authority,
challenging the
that will
investigation.
fix the issue.
Yes.
That 166, the procedure prescribed under section 166A of the code is the only and only one procedure. There is no other procedure. Is there any authority?
No, my lord, if
That will cleanse the issue.
if I put it
That
in
will
this way,
make my
lordship-
task
lordship,
easier.
my lord, let me put it this
Otherwise,
way.
otherwise your submissions are noted.
Had it been a case that the materials are collected, my lord, within the territory of India. Now here lordship will see it stands on a different footing because the evidence has to be collected from outside India. Now the case laws which covers, my lord, the issue, most of the case laws are relating to evidence collected by the investigating agency within, my lord, the territory of India.
No, no. My question is very precise.
My lord.
Whether do you have straight authority, direct authority on this point?
Well, only one High Court judgment, the Madras High Court judgment regarding Jayalalitha's case. That High Court says it's a mandatory, my lord, provision. So if that be so, my lord.
Let us read.
Yes, yes.
We have hardly time today, but let us read the,
My lord.
so that PP can respond to it. Citation?
Citation, my lord, it is 2002 Criminal Law Journal.
2002.
Criminal Law Journal 3026. With regard, my lord, this is the
3026.
Yes.
Okay. Para.
Para, my lord. She will give a moment, my lord. I will place the para. Uh, 14.8, my lord.
14.8.
Yes.
What does it say?
My lord, if I read it, Section 166A of Code of Criminal Procedure expressly provides that the evidence so taken or gathered pursuant to the letters regulatory issued thereunder should be forwarded to the court issuing such letter. If that be so, the intention of the legislature expressly provided under 166A of the Code of Criminal Procedure cannot be supplemented by any other procedure. It is also well settled in law that there can be no justification in adding or ignoring any word to make the provision of law more or less stringent than the legislature has made it. Therefore, in violation of the procedure prescribed under 166A of the Code of Criminal Procedure would render the proceedings improper and unfair, resulting in miscarriage of justice. So this says, my lord, that this procedure has to be adopted and any other procedure may not be permissible. More or less it says that. But to, my lord, buttress my argument regarding your lordship's query, I have to make some more research if your lordship finds it, my lord, to go further ahead with this, my lord, hearing.
No, if an authority
has already taken a view.
No, I am not
Be
taking,
back.
I am open. That is why I am asking that if something in support of your submission.
Yeah. Because your lordship will see more or less I am not challenging the investigation. If I am not able to
Because
put across
an
my point.
investigation may be perfunctorily or maybe was carried out.
Exactly, my lord, that is
in
a
violation
position.
of some prescribed procedure resulting into a charge sheet. Now, you say that that procedure, what was advised to be followed under section 166A is mandatory.
Yes, and it has a direct effect on my lord, right under 21.
That is
Yes.
going implication in a criminal offense, whether that violates Article 21,
That has to be, yes, this will be a
That-
broad proposition of law.
that you have to substantiate. Mere implication in an offense, a person as an accused in a criminal offense is a violation of fundamental right under Article 21.
No, in
That you have
respect
to
of the
substantiate
methodology.
because I'm not, it is not imbibed in my mind as of now.
In fact, that is why, my lord, the Madras High Court has, my lord, held that would be, my lord, improper and it will cause miscarriage of justice. In that view of the matter, my lord.
Okay.
I'm also on that, Lordship. Even though there is some procedural lapses, Lordship, if the other evidences are trustworthy, then the case will not go, the case will sustain, Lordship. I will also place on that.
My lord, this is my long and short, my lord, argument. Your lordship may take it.
No, if you, because you are saying that I'm not that convinced as regards that this is the only one and only one procedure. I'm not that.
In respect of collection of evidence from outside India, this is, my lord, the only procedure.
Okay, that is the only submission.
Yes.
Time permission or we can close this.
Close, your lordship may close it.
I will place this as judgment.
No. Then don't. If we can close this, thereafter no. If you want time, then we can fix it day after tomorrow or something like that. If you want to. Hired Mr. S.K. Talukdar, Learning Council for the petitioner. For week given us. We'll take up at 3. Then. 3. Day after tomorrow. Well, if he wants to supplement his submission.
Let him submit.
And Mr. P.S. Locker, and additional public prosecutor, Assam, representing the state of Assam. I, the respondent number 229, post of as sought for by Mr. Locker, place the case on day after tomorrow. The matter will be taken up at 3 p.m.